All right, folks, those of you who are contributing your presentations or papers, Matt Bodie is the man to talk to, because the proceedings of our conference will now be published as part of the ABA Journal of Labor and Employment Law, which I'm told has 35,000 readers. Is that right?
Give or take.
Give or take a couple of hundred. I'm one of those readers, and I'm so happy that we have this partnership with the ABA and with Matt Bodie, who is...
Sam, you took my mic. Oh, there you go.
I think we have an extra one here. 1, 2, 3.
Is Professor Kim here? Okay. All right, the previous panel set the stage in the discussion about the huge data collection and its use and everything for what this panel, I assume, is going to be talking about, stuff that we refer to as big data and data mining and its impact on employee privacy and discrimination, how that data is used once it's collected. So we have a distinguished panel here. I don't know the order that they have chosen to speak in, but we have Professor Bodie from St. Louis University School of Law and Professor Pauline Kim from WashU School of Law, both of whom have written extensively in this area. And then on the practitioner side, we have management lawyer Michael Gray from Jones Day, union and employee lawyer Lori Burke-Weiss from the Burke-Weiss Law Firm, and another management lawyer. We've got this properly weighted here, and a management-oriented moderator, Heather Sussman from the Orrick firm. And without further ado, however you guys have decided and Gary have decided you're going to do this, get going.
Yeah, I think we're going to start out, Fred. We're going to have, Matt is going to give some initial comments. He's done some incredible work in this area. St. Louis, by the way, very well represented on this panel.
Let's go Blues.
Yeah. And then Pauline is going to give, I think, a very provocative sort of analysis of the impact of AI in discrimination. And then we have Heather coming at it from a privacy background, Lori from representing employees and the challenges in litigation. So we're going to have a couple of initial presentations by, I think, 2 of the leading experts in the area, and then a moderated discussion to talk about everything that the research that Matt and Pauline have been doing. So, Matt, without further ado.
All right, thank you. Thanks to Sam and Tori and Allison and all of you for being here. We're very excited about the new partnership. If you're not a member of the ABA section of Labor and Employment Law, I'd encourage you to sign up. There's a lot going on there. We have the annual meetings in November every year. And there's a lot of subcommittees, subsections that meet. I know a number of you have been members of those sections, so I'm sure I'm talking to the converted on some level, but if you haven't done it, I'd encourage you to do so. And it's a little harder to get. You used to get the journal automatically sent to you, but the section made a decision to decide to kind of cut down on paper costs. So you can get a paper copy of the journal if you select it. You have to opt in rather than opting out. So, or you can get an electronic version online as well. And also I wanted to shout out to my Region 2 former colleagues, and very excited to be a former NLRB field attorney. So I am going to be talking to you a little bit about privacy in this area, and the kind of big theme of my talk is that employees are kind of embedded in this AI, right? They are embedded in data analytics. They're embedded in the kind of fabric of the new workplace, which is digital, which is observational, which is comparative, and it's something that has existed for a while in various forms, various aspects of it, but it's also some very new aspects to it, and I want to talk about that. So I want to start with the story of Enron. I'm sure most of you are familiar with the story of Enron, the company that was flying high until it flamed out in bankruptcy because of its basically accounting ledger domain a great book by Kurt Eichenwald, Conspiracy of Fools, if you haven't read that. But Enron lives on through its emails. You may not know, but the Enron corpus, as it is called, is the basis for a lot of AI. And what is the Enron corpus? Well, FERC, when it was done investigating Enron, dumped over 1.6 million emails onto the internet in 2003. These emails were between about 150 executives, senior, junior level executives at Enron, and they were designed to show kind of how Enron had kind of gone down this path. But this data set, again, of 1.6 million emails was pretty soon seized upon by researchers as a great example of people just communicating. Now, there's been a lot of criticism of using this particular corpus of emails to generate AI, right? As we talked a little bit about yesterday, the data that you use to generate AI may inform your AI. And maybe just maybe some executives at an energy company that's flaming out and going down the tubes, and they're implicated in a variety of crimes and fraud, and maybe trying to cover that up or deal with those ramifications. Maybe that's not your ideal use of AI, but it was a huge data set of people interacting, and it was used by researchers to really kind of formulate a lot of the data upon which the AI systems would learn. Right, so here's just one example, right? All those those are people, right? Actually, they're email addresses, but the email addresses were the names of the people. FERC did decide at some point, maybe we should go through and cut out some of the personal emails that were dumped onto the internet, and they did do that, but there's still a lot on there that is personal. A lot of the Enron folks were very upset about their emails being dumped. And so I think this is just one example. Again, there's been a lot of concern about, is this the best way of creating AI using these emails? But from my perspective, we also need to think about, this is data generated by employees, and it's taken and used for other purposes, and the employees have some real privacy concerns about the use of that. And why was this used? Because it was available, right? Since then, obviously, big companies are going to have their own data sets of employee emails that are even significantly bigger than this one. And if you're a company, you might be tempted to say, hey, this is a data set. What can we do with this data set, right? It's going to raise a lot of, obviously, privacy concerns. So one of the things I just want to kind of leave you with today is that kind of a framework of thinking about the role of AI and employees within that role. Employees are sources of AI data. They're also subjects of or objects of AI decision making, and then they also are users of AI processes and facilitators of AI. I want to talk about each of those individually. So obviously, going back to Taylorism and scientific management, employees' work has always been studied. It's been a source of data. And Moneyball is kind of an example, kind of a new use of data. But again, Moneyball is not really a change in the data itself on some level. We're just using walks in some ways. So one of the big innovations of Moneyball is that, hey, let's look at the walks in a way that's not covered by batting average. I like to point this out because I don't know if you can see Bodie up there. Ping Bodie, no relation, because his actual name, let me get this right, he was named for the town of Bodie, California. His name was Francesco Stefano Pizzolo, so no relation to myself, sadly, because he was quite a good baseball player. But sports has been one area where we've been taking the data, looking at the data, and examining the data of people's workplace. This was a Business Week cover, Managing by the Numbers, and those, just to kind of illustrate some of those things that this is a cover about IBM looking at its employees. So the amount of time they spent web surfing, their emailing, their allergies, their social network participation. What did they expend for client entertainment? How much time did they spend on the phone? Sales, marital status, distance from the airport. 2008, I think, is relevant. This is from 2008, right? Over 10 years ago. So this has been going on for a while, but there have really been kind of some huge leaps, particularly in AI ability, but also our ability to kind of manage the data that we're getting. This is one somewhat recent innovation you may have read about. It's actually a book by Ben Weber, who has his own company called Humanize with a Y. It's been at the MIT Media Lab. his book's called People Analytics, and he largely studied the use of this sociometric badge, which keeps track of where you are, keeps track of who you're talking to, records your conversations. Now, they were recorded not for the content, but for the tone. So are you speaking quietly? Are you speaking loudly? Are you speaking emotionally? Are you making a joke, right? That data was collected, and then it was compared with how these folks were performing, and you could say, oh, the people that traveled around the office more, spoke to more people, spoke in a respectful tone, maybe, those people were better performers, and that's something that we can think about in terms of evaluating them. But there's this huge division that we've had, or I shouldn't say there was this huge, there's this kind of idea that we have, this desire, I think, that we want to separate out work from personal life. I don't know that it's ever really been possible, but I think that line is just becoming almost meaningless these days. Some of what Professor Secunda was talking about in terms of our work life bleeding over into our personal life, but also who we are as a person bleeding over into evaluations of our abilities at work. Obviously, headlines like this are ones that grab attention, and I think some data folks talk about the creepiness factor as kind of a scientific term almost. Like, what is the creepiness factor of this thing that we're proposing? We want to kind of make sure that we lower the creepiness factor. This is something that would be, I'd say, a little high on the creepiness factor. But even something like this, I don't know how many of you read the article about Charles Duhigg in the New York Times Magazine when it came out, but Google did a study of their teams and tried to figure out who was performing best in the teams, which teams work best, and found that those that allowed for conversational turn-taking, social sensitivity, and were psychologically safe were the ones that really bonded and were more productive than other teams. But there's a quote from the article that I think is interesting because it was framed kind of positively. The quote was this from one of the participants. I had separated things into my work life and my life, but the thing is, my work is my life. If I can't be open and honest at work, then I'm not really living, am I? And the article had related how a senior researcher on the team had told everyone that he had stage 4 cancer, and that had really kind of changed the dynamics in a positive way, and that it allowed people to be more open and more sharing. And so it's interesting. If you read that article, it's framed very positively, but if you're thinking about it from a privacy perspective, it raises a whole host of concerns and questions about the extent to which we're handing over our personal information and our lives to work. To what extent are we doing that? Are we asked to do that? Employees are also objects of AI decision making. These are some of the examples in which AI is used to provide suggestions for employees. Obviously, this goes back a long time as well. If you haven't read Fordlandia, I'd really recommend it. It's a really interesting book about the Brazilian rainforest rubber tree plant that Ford created to get rubber for his tires, for his cars. But it carried over some of what his sociological department was doing in the United States, which is really kind of looking at workers and saying, you shouldn't drink, you shouldn't use tobacco. No football was one of the things that was prohibited at Fordlandia. Anyway, looking at employees' private lives and saying we can improve them as workers by shaping how they live their private lives. In data-driven HR, you're seeing AI come into work with things like facial recognition, personality surveys, games. How well you perform on a game might impact your score. Again, we heard yesterday about millions, thousands of applicants, right? How do you differentiate between those? Those might come into play. Google has had its people operations. It's used data to drive HR decisions. I'm just curious, how many people have worked with a company or work at a company that use Agile or Lean Startup as kind of an HR framework? Anybody? Okay. I've read that it's very popular in the tech industry, but I was wondering how popular it was more broadly, and it doesn't look like it's as popular. Pardon?
This gentleman over here.
Oh, pardon?
Is someone over here?
Oh, okay. I'd love to talk to you about it a little bit if you're open to that. All right, so, and this is a little bit of a facetious comment, but might an employer, in terms of an HR decision, say, you know what, we've monitored your physiometric kind of performance, and we know that you're kind of lagging a little at 2:30, So, well, this is one kind of performance-enhancing drug that we think about for athletes, but might be another that is assigned to you. I think most of us self-assign this kind of performance-enhancing drug for us. But what are we doing, right? We're often drinking coffee so we do better at work, right? So are there long-term effects from caffeine? I seem to read like every other month there's a coffee is good for you, coffee is bad for you, coffee is good for you. So I don't know, maybe it's actually healthy as well. But in any event. Finally, employees are also AI users. There's a lot of AI-assisted decision-making in employment space, but there's also AI facilitators. The Mechanical Turk system of Amazon, folks willingly participating in studies and data driving. And if you haven't read the Verge article about the Facebook content regulators, it's a tough article to read, but I'd recommend that you check it out in terms of the trauma that these folks have experienced. All right, so let me run down through some of the legal protections that are offered in this space. As data sources, we have the privacy torts. Public disclosure of private fact, there's probably not going to be public disclosure, but intrusion upon seclusion is definitely something that is available. Be happy to talk more about that. Hasn't come up all that much in this space, I think, because of some of the problems with bringing tort actions, but it's definitely available. There's a lot of states, over half the states now, I think it might actually be up to close to 50%, prohibit employers from getting passwords for social media accounts from their employees. The Consumer Privacy Act, there's an amendment that might exclude employees from the California Consumer Privacy Act, but right now they are covered, and it'd be interesting to see how that might affect the use of employee data. And finally, right of publicity, right? The right of publicity comes from a company using a picture of someone without their consent. Again, for most employees, there would be consent available, but I do think we're seeing in the data space the value of data, who owns the data, who gets to use the data. If there's a fight over data, we might start talking about employees getting compensated for their data. Health information is protected through these statutes, but not that particularly. If you're a self-insured company and you have health information, and HIPAA does, in fact, regulate your use of that information. I have not seen too many horror stories about the information bleeding over from the health insurance into regular use of AI or data in HR, but there's that possibility. It could be used for that. And the Illinois Biometric Information Privacy Act, I think, is probably the biggest statutory protection in some ways for this type of use of data, in that it really requires you to get very specific consent, and also requires the elimination of the data at some period of time after it's been kept. More of a European model, which is what I'm going to talk about now. The General Data Protection Regulation has a variety of restrictions, not just on collection of data, but also processing, notification, and requires destruction of data if it's no longer useful. Interestingly, in the US, consent kind of wipes out a lot of employee privacy protections, because intrusion upon seclusion is one example, because if you get consent, it's generally seen as a defense to intrusion upon seclusion claim. But the GDPR explicitly says consent is not enough in a relationship where there's a power imbalance such as employment. So they take a very different approach to consent over there with that regard. And what that means is that companies will have to trust that their balancing test, saying, you know, our use of this data is important enough that it outweighs the privacy concerns. It's all going to come down to litigation and seeing where the courts kind of end up, particularly the Court of Justice of the European Union. But right now, consent is not going to be a blanket waiver in the EU. Professor Kim is going to be talking about discrimination in this context, but think about if there's data collected and said, you know, we don't want people who are busybodies and always talking to their fellow employees about concerns they have at the workplace, right? What if that's built into the AI, right? Seems like there might be an 8A1 charge there. Whistleblowers, public policy, kind of a similar thing. The Fair Credit Reporting Act, importantly, there are particular notification requirements, and employers can really get tripped up if they don't follow those requirements. If they do have good counsel and they follow the requirements, then it doesn't really protect employee privacy that much. in terms of, in that the notification can be used to provide, as long as the notification is provided, you're not going to be in violation of the law. But there are some substantive requirements there as well, including some authorization requirements, so you'd be looking at consent in some contexts. All right. State law protections. Think about, again, if you have an AI that's making decisions based on people's politics, right? And again, if you don't know how the AI is making its decision, then it might be making its decision based on these things, and that's going to be problematic. California has a very strong political activity state law prohibiting discrimination against employees because of their political activity. It's not, this was mentioned yesterday, but the Artificial Intelligence Video Interview Act is not yet signed by the governor, I believe, of Illinois, but it has been passed by both chambers, and basically allows you to opt out of a video interview if you so desire. One thing we haven't really talked about much at this conference is cybersecurity. If you are collecting a lot of employee data, and that data is stolen or accessed or hacked into, there are a lot of cybersecurity requirements. I think the Sony Pictures example from a few years back is a good example, and there's a class action litigation about that. As an employer, you really have to be careful with your employee data, and there's going to be some real strong ramifications of failing to protect that data in an appropriate manner. All right, so one other thing with regard to AI HR, Article 22 says that you have a specific right not to be subject to decision making solely by automated processing. And that is, again, I think it was been mentioned that that might be helpful in keeping employees involved, humans involved in some of this. And there's a special category for personal data here as well. So if employees, again, this applies in the EU, but if employees are active in saying, you know, we don't want to have decisions made solely by AI, they have the right to opt out of that in the EU. And finally, these aren't really privacy concerns, but I do think they go to autonomy and kind of a status. Are we just individual kind of data points within the machine? And I think particularly folks who are working as AI facilitators, the folks who are working Facebook content regulation and folks working on Mechanical Turk can feel so kind of disaggregated from their workplace that they really lose a sense of having participation in some larger enterprise, which is, I think, really when we're thinking about employment, it is joint organizational activity to pursue some common goal, right? That's why we have firms, right? That's why we have companies. And if we lose track of that, I think that would be a real shame and kind of further increase a lot of folks' sense of alienation within our society. So thank you very much.
Thanks, Mike.
Okay, great. This has been a terrific conference so far. I have learned a ton, and there are so many different strands here that are sort of overlapping and coming together. But I want to talk about one very specific, narrow, fairly, well, maybe it's bigger than narrow, but one specific issue. So to frame this in terms of what Matt was just talking about, one of the ways that AI is used in the workplace is to make employment decisions. This is AI acting on the employees as the objects of AI. And so there's been a lot of discussion about what is AI, so to be clear about what I'm talking about, I don't really know that I can come up with the definition of AI, but what I'm concerned with is predictive algorithms. When AI is used to make predictions about workers that will control their access to employment opportunities. And in particular, I'm concerned with the question of whether using AI will increase or decrease instances of bias and discrimination. Now, I think the panel yesterday afternoon that talked about how AI is being used in the workplace covered a lot of these issues, and I think that they really explored in a pretty thorough way some of the risks of relying on AI, the risks of discrimination and bias, and also some of the things that companies need to be doing to be careful that they're not creating these risks. So I'm going to just do a real quick recap here of some of the points that were raised yesterday, and then move on to some other areas, including how the law might apply. So one of the things that we talked about yesterday was proxy attributes, that there are, when AI is built using these incredibly rich data sets, you can have things like, and this is the example given yesterday, zip code, which if it is used to predict things like job performance, guess what? Zip code correlates to a large extent with racial identity in our cities because of historical segregation. So the possibility that there are proxy attributes in the data can lead to a risk of bias. Another possibility is that the AI is built on biased data itself. And there's a common, sort of a recent, there is a recent example of this. Amazon tried to build a tool that would go out and look for promising employees who would make great software developers. And so they sort of built this system based on AI, and they trained it by feeding in information about their current software developers who, by the way, were overwhelmingly male. And so the AI tool learned to favor male software developers over female software developers and learned to discount, for example, resumes that had listed a women's college, for example. So at some point, I think the report was anyway that Amazon gave up. They couldn't get rid of the bias, so they got rid of the tool. So there are other ways, I won't go through this in detail, but basically because AI is built by training the model on a set of data, what's in that set of training data is really important. So if there are variables missing in that data, if there are errors, and particularly if they're unequally distributed, in other words, if some groups are more likely to have errors in their data, or if the data set itself is unrepresentative of the population it is trying to predict, all of those data problems can produce error and bias in the predictions that the model is producing. So what this means is that the use of AI and these risks of discrimination pose a lot of challenges to anti-discrimination law. We've talked about proxy variables. In terms of unexplained correlations, one of the things that AI can do, it depends on how it is built, is some of these models are quite atheoretical. They just collect a lot of data and they look for patterns. One of the examples that was mentioned yesterday is this study from England a few years ago that found that liking curly fries on Facebook was correlated with higher intelligence. Now, this is not a causal relationship, right? I would posit it is not a causal relationship. Nobody would go out and eat lots of curly fries to try to raise their IQ. But if this kind of a observational correlation is built into a predictive model, the problem is because it's not a causal connection, the relationship could change over time. Maybe curly fries were really popular among the intelligentsia for a while, and now they're not anymore, right? But if you're making decisions based on these correlations that are not actually causal, you have a problem down the road because they may introduce errors and they may do so in a way that is systematically biased. Another challenge with that AI poses for anti-discrimination law is simply the complexity of the model. So this is a picture of what's referred to as neural networks, where basically you have the X's are the input variables, the Y's are the output variables. You have these various layers in the computer that are processing these in a way that becomes very opaque even to the programmers who built these models. So there's a problem with the opacity of the models. We don't always know what's going on in them. The other thing you might have heard about, right, is one of the things that AI purports to do is to learn, right? And really what that means is if you have a model and you're constantly feeding it new data, then it can just update based on that new data. And so that poses a challenge as well, because it means that the model that is being applied today to predict who's going to be a good employee and should be hired may be entirely different a week or two or a month from now when new data has been entered and the model has been updated. So this issue of real-time updating can be a challenge as well. So the last challenge that I want to talk about is the role of labor market intermediaries, and this is something that I think we haven't really heard talked about much today. And this is the question of what information workers receive before they even apply, before they even connect with a company. Because tech intermediaries like Google, like Facebook, like job matching platforms like ZipRecruiter are playing an increasing role in shaping the labor markets and how workers find out about jobs and how they come to apply for them. So you might have heard about some recent litigation against Facebook. There was recently a big settlement that was announced, I think it was in March of this year. And there were several different lawsuits brought. They were brought by housing advocates and also employee advocates. And the charge was that Facebook was allowing employers and landlords to target their advertising based on protected characteristics. So any advertiser can go on Facebook and they can select a number of attributes that they want their target audience to be. And this can be things like, you know, people who are blues fans in St. Louis, or people who like cats, right? Or it can be demographic, things like between the ages of 18 and 35, for example, or it can be men only or women only. And so the allegation in the lawsuit was that Facebook was allowing employers and landlords to use these categories to target their advertising in a way that allowed them to discriminate. And so Facebook finally settled, I think it was 3 or 4 of these cases altogether, and they said, you know, this is not how we intend this tool to be used. We understand that housing, employment, and credit are particularly sensitive areas. And so as part of the settlement, they agreed to create a special portal that would be, that anyone advertising for housing, employment, or credit would have to go to this special portal. And in that portal, unlike the person who's advertising to sell you shoes or cat litter or whatever, right? If you went to this portal, if you were a housing, employment, credit advertiser, you could not use one of those selected demographic categories, and you couldn't even use attributes that are closely correlated with those. They were trying to get rid of the proxies, things like, I think one of them was young and hip, right? Or, you know, soccer moms, so these would be indirect ways of discriminating. Those attributes would be unavailable as well. A few days after the settlement was announced, HUD filed a charge against Facebook. And many people were like, why is this? Facebook just decided to, you know, enter into this great settlement agreement. Well, the reason is that even if, let's take the example of an employer, chooses an audience that is entirely neutral. In other words, the employer wants this advertisement for a job posting to go equally to men and women and all demographic groups, all age groups, right? Even if the employer targets it on a neutral basis, Facebook's algorithm decides who within that target population will actually receive the ad. And that algorithm that's run by Facebook can itself have discriminatory effects, even if the employer wants to reach a broad audience. So there was a paper that came out around the same time as the settlement. A number of computer scientists posted real employment ads on Facebook. And they found that, that the delivery of these, even though they asked that they be distributed on a gender-neutral basis, the delivery of these ads reflected traditional patterns of occupational segregation. So for example, an ad for a nursing position went overwhelmingly to women recipients, and an ad that advertised, I think it was lumberjack and other sort of traditional labor jobs, went overwhelmingly to men. And why is this? Well, we don't really know because Facebook, you know, has their secret algorithms. But we can guess that what Facebook is trying to do is to maximize revenue. They do that by using their algorithm to predict who's most likely to interact with this ad. And they do that using past data about what they know about people, their preferences, their work, and so on. So basically, if we have a world, which we do, in which there are occupations that have distinctive race or gender profiles, those are going to be reproduced in where Facebook is sending the ads, right? And so this is affecting the information that people have about their opportunities, and ultimately affecting, I think, how the labor market is going to operate up front. Okay, so so all of these things, I think, pose some real challenges, as I said, for existing anti-discrimination law. But let's talk a little bit about the law. So, you know, the obvious first place to look is, well, if we're concerned about bias and discrimination in algorithms, let's look at Title VII. Title VII, very familiar structure, right? There's disparate treatment cases, there are disparate impact cases. Disparate treatment cases are cases involving intentional discrimination. Disparate impact, there's a whole thing about, you know, is there a disparate impact? And if so, the employer has to show it's job-related and so on. And so the disparate treatment model would work pretty well if we could prove that an employer was using an algorithm knowing and intending that it caused discrimination. But that's going to be hard for a number of proof reasons. And I think often employers really just don't realize what the impact might be of some of these tools. And so disparate impact seems like maybe that would work, right? It's maybe a facially neutral policy that has unexpectedly or unintendedly some adverse impacts on protected groups. And I'm going to talk about it in a minute. I think that existing disparate impact doctrine, because it evolved in a different context, it doesn't quite fit, and there's some ways in which we'll need to adjust if it's really going to address these problems. But I do want to remind people that there is another part of Title VII that is often overlooked, which is 703A2. It prohibits classifying employees or applicants in a way that would deprive or tend to deprive them of employment opportunities because of race, et cetera. And after disparate impact doctrine was codified in 703K, people have sort of forgotten about A2, but it's still on the books. And I'm not sure it's exactly the same thing as disparate impact, which was codified in 703K. So I think there may be some room to think about how this part of the statute maybe might apply to AI decision-making in a way that would allow courts to be a little bit more, a little bit less constrained by existing doctrine, and to use this language in a way to really try to address the problems of discrimination that are raised by AI in the workplace. So what are the adjustments that I think will need to be made? Well, the first thing is, I think employers should have a responsibility for preserving sensitive data about demographic characteristics like race, sex, and so on. Purging those variables from the data set will do nothing to prevent discrimination because there of the possibility of proxies being used instead. But we will need that sensitive data in order to assess what's going on, right? In order to figure out if there's actually disparate impact, you have to know how it's affecting different groups. In terms of the employer burden, and this I think really relates to a lot of the conversation yesterday, if there is a disparate impact, what is it the employer should have to show? We talk about under disparate impact, job-related and business necessity. What does that mean? In the context of AI, I think that that means that an employer should have the burden of proving the statistical validity of the model. And this may mean, by the way, the employer getting the vendor, right, who sold them the software to establish the statistical validity of the model. But they should have to answer questions about things like, what were the data sources that you used to build this model? What is the data representative? What was the choice of the target variable, the thing that you decided to predict? Is that a legitimate thing? How did you construct the model? What kind of variables did you put in there? That kind of defense burden needs to be put on the employer if they're going to use these kinds of models. The third thing, and this goes back to my curly fries example, right, is that merely being able to point to a correlation, no matter how strong the statistical relationship, should not be enough to justify the use of a model. The employer should have to show some kind of job relatedness for the criteria that it is relying on. The fourth one and the fifth one, I kind of have question marks there because I'm still thinking through these, but I think maybe In terms of employer defenses, maybe we need to rethink a little bit the bottom line defense, which the Supreme Court rejected in Connecticut v. Teal, or otherwise think about some kind of safe harbor for employers. Because what we want to do is create an incentive for employers to actually audit these systems and keep an eye on what they're doing, not be afraid of liability. In other words, not be so afraid of liability that they just say, we'll just trust the vendor and we're not even going to look at what the effects are. They should have the incentives in place to actually do the right thing and figure out what's going on and then take steps to try to mitigate or revise. And then the fifth one, I'll just goes to my example of sort of Facebook and Google and other labor market intermediaries. This gets really complicated, right? Can they be held liable under Title VII? They're not employers. Could they be agents? And this is a paper I'm currently working on, still thinking through. Maybe we can talk about it a little bit in Q&A, but I won't stop here. Okay, and then the last thing I want to suggest is that because of all these challenges that will arise in trying to fit Title VII and adapt it to address the challenges of discrimination in AI, I think we need to think about regulation coming from another direction. Not only because I think it might be more effective in preventing discrimination, but also because I think it's probably coming, which means that employment lawyers and employers who are using these systems need to be aware of this other regulation that's not specifically about employment, but is very much potentially going to affect employment. And so I won't talk about each of these laws individually, but the general thrust behind the GDPR, Matt talked a little bit about the right not to be subject to decisions solely based on automated processing. The GDPR also provides a right for individuals to receive meaningful information about the logic involved when they are subject to automated decision making. But the GDPR also does a lot of things that go beyond individual rights. And these are things that are intended to try to ensure systemic accountability. So companies must appoint data protection officers. They are encouraged to use third-party audits. They are required to conduct impact assessments. The Algorithmic Accountability Act, which is simply proposed right now, but if it were to go anywhere in the US Congress, that would also likely require any company using an automated system that involves high-risk decisions, certainly that would include employment, to conduct an impact assessment. And the goal behind this sort of line of regulation is to try to address some of these problems up front, to encourage the development of technical standards, best practices, to intervene early in the process before an algorithm is actually put in use, but to make sure that it's being built in accordance with these principles in a way that there's some transparency and some accountability. Now, I will say that there's a lot left. I mean, the Accountability Act in the US is not even passed yet. The GDPR only applies in a limited way in the US. So a lot of this stuff is pretty far down the pike. But I think it's coming. And a lot of what the effects will be will depend on the details of how these systems are worked out and whether they can be built in a way that doesn't squelch innovation, but ensures that there are enough guardrails in place that this technology, when it is used in the workplace, is done in a way that enhances equality and non-discrimination rather than increasing the risks of bias. So I'll stop there.
Thanks, Bob. So Lori, Pauline posed the question whether or not the use of AI increases or decreases the risk of discrimination in the workplace. Have a pretty good idea of your thoughts on that, but maybe you could tell the audience.
Okay, we've been steeped in this, and I'm only an employment lawyer. I never took calculus. All this math stuff is, giving me a little bit of a headache. But that's important because I think it's going to give a lot of us headaches going ahead. I think that because we've got a black box, and I think, Pauline, your comments really underscore the difficulty in understanding exactly how AI is used, how the algorithms are developed, what goes into them. And, you know, assuming the best of people, which is not always a good idea, but we will for this discussion, nobody intends to discriminate. And yet, with all the different elements that go into machine learning, again, my understanding is that the algorithms that are developed are almost like a neural network. They're constantly taking in information. Maybe there's no list. I wonder, Professor, if we can ever really know what goes in any particular algorithm. And then you've got an employee who either didn't get a job that they thought they were qualified for, or didn't get a promotion, or somehow got cast aside in a succession planning process. And how are they going to figure out what happened? You know, I represent employees who, you know, often believe they've been discriminated against, and as we all know, oftentimes the key words haven't been said, the smoking gun isn't apparent, you're going on, you know, you're going on evidence that you aggregate to make that determination. You try and pass that Iqbal test if you're going to bring a lawsuit, and then you go into discovery. And even without AI, the employer holds most of the cards. And with e-discovery, it's really expensive to get those cards. Again, assuming that people are telling the truth at a deposition, which isn't always the case, or that you've asked the right question as the lawyer doing the examination. You know, when you start uncovering evidence that requires a forensic to look at it, that requires the services of an expert. I mean, again, I don't know any math. I need somebody who's going to interpret these algorithms and be able to unpack them. How do I do that as an individual plaintiff? So I think we've got a lot of challenges ahead of us if AI comes into a case, and what I'm hearing is that increasingly it will. And I mean, I got a few blasts from the past here thinking about Local 6, the Typographers Union, how they put themselves out of business a long time ago, thinking about Hal, and he's not here to defend himself, but I told Howard, you said that, you know, that computers can't drink, they can't discriminate, but Hal killed people. So what are we up against? You know, I think there are, you know, well, I can go on and on because I'm just thinking what you folks are probably, you know, mulling over as you hear all this information, assuming that, I mean, is there anybody in the room, I know one, who has expertise in AI? Anybody? Okay, there are a few. Are you lawyers as well as, okay, so.
That's why we went to law school, because we hate that.
Let me ask get Heather's
Yeah,
point.
because
And,
I
you know,
sorry.
you hear what we're talking about.
Yeah.
Matt wrote this brilliant article on sort of the Freakonomics, applying that to the workplace and how HR could actually have, I think, Matt, you described as sort of revolutionary insights into human behavior. So, Heather, your job is working with companies, trying to tap into those revolutionary insights that Matt talked about, but at the same time balancing the risks that we heard from Pauline, Matt, and now Lori. Are there some good practices that companies should do to try to take advantage of the best of AI while balancing the legal risk?
It's a great question, and I think, yeah, it's expensive to bring these cases, but it's also expensive to defend the cases, and so that's the reason building a good compliance program around how to onboard these AI tools is so critical. You've heard a lot over the last 24 hours about the risks. What are the risks? So what I'd like to focus on is, well, how do you operationalize? How do you mitigate those risks for your organization and still have the benefit of the access to some of these tools? And I would say follow 4 key steps. And the employee component is an important part of each of those steps. So on the first one, it's this concept of diligence, right? Diligencing the AI vendor and the tool. It is not enough to walk into a litigation and have to defend the data that went into it or the determinations that were being made. If you're approving the use of this AI tool, I would say it's important to really understand how is it going to work. Roll up your sleeves. Yes, we hate math. And so we might have a natural tendency to say, I don't want to do it, I'll leave that to someone else.
That's what associates are for.
There you go, because they're probably chomping at the bit to do this. But you really do need to ask those questions at the outset, and that's part of diligencing the tool. That's before you even enter into the contract and you onboard that tool, whether it's your own internal data scientists that are building these models or whether you're going, so it's always the debate, buy or build, buy or build. Do we buy the tool or do we build it in-house? But for you all, anyone who wants to be ultimately responsible for making a decision of what tool is going to be used, it's so important to diligence and really walk through that whole life cycle. What data is going to be ingested? Where does it come from? And you sort of diligence those whole data flows to make sure you have the right consent if you need consent. Or maybe you don't need consent. Maybe it's synthetic data or proxies, but then push. What are those proxies? What are they based on? And you sort of follow the flows of the data through the models. How are we making decisions? Let's show us some samples. Let's run through some test cases where you actually practice the modeling of the data. Diligencing through that process, and all the way through to the output. Okay, so what is this going to look like? What do the results look like? Actually see copies of sample reports and outcomes, okay, to know from this data, am I going to be able to make determinations about whether we see bias in the outcomes? And what happens if there is bias, right? Because you're going to want to think about how to work with that vendor in a buy situation, or if you're building it internally, what are your processes going to be for then who's responsible to identify if the bias is flowing through those algorithms, and what's the process for going back in and adjusting that? Don't just take for granted that someone's got their eye on that ball. Actually walk through that process and figure it out. There's also, so many different AI tools out there available. I think this huge proliferation. It's not just for use for HR data-driven analytics, but it's also for many different consumer insights. So you'll have employees that are going to be using these models as well. And so understanding how the employees are using those tools and really, I think, rolling up your sleeves and getting to know that is so key. So that's step number one. I'll try to speed up on the other. So if conducting really effective due diligence, the next step is contracting and having good contracts in place. If it is a vendor that you're going to, think through what happens if you do have some of those issues, right? It's not enough for them to say, well, that's proprietary, we can't share it with you, right? Or maybe you decide at the end of the day how to solve some of those tensions. That needs to go into the contract. The biggest issue we see in contracting today is CCPA, the California Consumer Privacy Act. Because what's going to happen is if you use a vendor, in order to qualify as a service provider under the CCPA, that service provider needs to agree in the contract that they will only use the data for purposes of delivering the services to you. But as any good data modeler, data scientist will say, is, geez, but by using your data, we build better models, and then we use those models. That becomes part of our product and service. That's actually okay under the CCPA. You can allow them to use the data to build better models, but what you need to make sure is that in the contract you make it clear that that's part of the service that they're delivering to you. Because once they start using data under CCPA for their own individual purposes, that can knock them outside the definition of a true service provider, and it may subject you, the company, to an opt-out right to that data, which once you get into dealing with opt-out and deletion rights with data models, it becomes very, very challenging and complex. So good contracting practices. The third I would say is don't just stop the contract. There's a process of onboarding that is so key. If you haven't figured out what your policies are around onboarding of these kinds of tools, I would say do that. What are your fair information practice principles? Look at the OECD guidelines that they talked about yesterday in the afternoon session, which defines things like notice, transparency, and choice. Think about, in the diligence phase, hopefully you've looked through the whole legal review, all the Matt's great list of laws that could potentially apply. You go law by law and you tick off to make sure, okay, we don't have the privacy concerns, no potential violations of those laws. But now how does that tool potentially fit within our own internal privacy practices, our principles, right? Notice, transparency, the concept of data minimization. How do we reconcile this? This is the privacy impact assessment that you were talking about. Okay, I don't think we need a federal law to tell us to conduct a privacy impact assessment. This is a terrific tool for minimizing privacy concerns and risk and minimizing the likelihood that you're going to end up in a lawsuit or litigation. If you can conduct a good, effective privacy impact assessment to look at all those laws, balance the tool and what it's doing versus the fair information practice principles, clearly identify what the legitimate business reason is for using these tools, right? What is the I say legitimate business reason, you said job related, but some of the tools might not necessarily be related to the job, right? It could be a consumer-facing tool that you might have. And so that's how you would conduct a privacy impact assessment. Do it under privilege, I would suggest, as your outside counsel. Don't just draft a privacy impact assessment where you're making these judgments about legal analysis and data minimization without actually conducting that exercise under privilege. Because a lot of times you're making these decisions in the gray area for purposes of giving legal advice to the organization about whether to accept or reject the tool. And so you want to properly protect that analysis and privilege. And so the fourth component, I would say, is ongoing monitoring and review. So you've done the diligence, you've got the right contracts in place, you're onboarding the tool in a way that's consistent with your existing privacy program, and you're ticking the boxes on your privacy impact assessment, documenting that carefully, and addressing privacy and security concerns as you go. The last point is ongoing monitoring and review of that tool. Whose responsibility is it? How is that going to work operationally? And then adjusting as you go, making sure you have good training of the people who are using the tools, but also good testing and modeling as you go to make sure you're accounting for things like we've been talking about today and yesterday, things like bias.
Paulina, I'm going to put it back on you. You said in your opening presentation that there should be an affirmative obligation on the employer to look at these tools before you use them. Heather just laid out quite the approach. Is that what you have in mind when you're talking about the affirmative obligation when you're using these kinds of AI tools in the HR world?
Yeah, so that was terrific, and I think I would worry a lot less if I knew that all employers were going through those steps with not from a purely compliance point of view, but really trying to advance these ethical and legal goals of minimizing harm, right? Considering privacy rights and discrimination and so on. So, and if you, some of the things that I said when I said the employer's burden should be to show these things if there's a disparate impact, they kind of line up to a large extent with some of the things that Heather was saying the employer should be doing on the front end going in. So to that extent, I think we're really aligned in what we're saying. I think the one point on which we probably differ is Heather said, well, why do we need a federal law as long as employers are doing this, right? And I think we do need some regulatory oversight because I don't trust all employers to do the right thing. I think some lawyers are companies are relatively unsophisticated. Maybe they don't have counsel who are helping them through this process. There are a lot of vendors out there who are promising all kinds of things. And if you don't have somebody with some sophistication about the data and able to ask the hard questions, you know, we're not sure that they're going to be doing the right thing. I think the other thing is, and this is one of the things that will be a challenge moving forward with the GDPR, and if this Algorithmic Accountability Act comes through, is what exactly is the public role? I mean, we've had this discussion before about allowing self-governance by companies. To what extent does that work, and to what extent do we need a little bit more of a public conversation? Do we need some accountability, some transparency about what companies are doing? It's one thing for the company to say, yes, we've gone through all these steps. It's quite another to say, well, has that actually been certified by a neutral third party? You know, that you have actually mitigated all of these potential harms. And so I think that's where a lot of the conversation on this regulatory side will come in terms of what might need to be disclosed publicly to whom, how do you do so in a way that protects legitimate sort of business interests. So maybe not all of it is like open to the public, but you may have regulators, you may have trusted third parties who do some of this certification.
I would say that, practically speaking, though, what Heather's laying out, that's going to be very difficult to imply for most employers. They're not going to be able to hire Heather and Oric to go through that. And the truth is, and it gets a little bit back to Chairman Ring's comments on joint employer, et cetera, oftentimes you're using this vendor because it's outside what you do. And do you have the internal resources or even the external counsel to be able to do that kind of diligencing? And then, you know, throwing it to Lori, someone walks into Lori's office, doesn't know exactly why they didn't get the promotion, doesn't know exactly why they didn't get the job. And Lori, when you hear what Heather's suggesting that employers do to try to create sort of the most sort of fair and balanced sort of workplace, what's your reaction to that?
I mean, I think it's what you said. I mean, not everybody can do that. And, you know, I actually did go to an expert. I'm lucky enough to have a young friend who has a PhD in statistics. And she does this kind of work, not in the employment side. But some of her comments were that, you know, that because these algorithms use enormous equations, that you really cannot link change in one input to the output. That, you know, given all the features of, for example, in a hiring algorithm of candidates who you let go through round one, I mean, you need previous data from a human screener to closely match what the human screener did. But what if the human screener had bias? I mean, the layers of complexity in this, it's like thinking, how does your brain work?
Lori, let me ask you a question on that, though, because there's been a number of studies on that that says that the human screener now is looking at less than 6 seconds, 5 seconds in every resume. And it's getting less because it's so easy to post for jobs right now. So going back to, I think, Pauline's sort of question that we're using as the premise, isn't it possible that the AI is actually providing a fairer approach to these extraordinary number of resumes rather than a human screener who is going quickly and looking at it for 5 seconds or less?
I mean, I would say it's a different approach. I mean, I gather, you know, some of these jobs that we're sort of talking about get 1 million applications. I don't really understand it all. It's probably so easy to apply to a job that anybody just sends their resume. So do you really need to look at 1 million resumes for 6 seconds apiece? No. Probably, you know, I said if you're looking for somebody who has widget experience, you run those resumes through a first line question, you know, you look for the word widget. And I mean, how many of those resumes are going to have that word? And then if you get there, you know, maybe there is an AI function that, I mean, that's not AI, looking for one word in a resume. AI is, again, these complex equations that are intended to bring in so many different elements. It's as though your brain was looking at it, but, you know, AI would say in a more unbiased way. I don't know. I mean, I think that you need the human element in this, and the human element is not totally divorced from it. So to think that by using AI, you're getting some, you know, completely neutral party that is making a fairer decision than a human being, I just think that we're kidding ourselves. It's a way of managing vast amounts of data, vast numbers of applications that probably shouldn't have, many of them probably shouldn't have been made in the first place. But, you know, you just press the button on Monster or Indeed and, you know, okay, I'll try that one. So, yeah, I mean,
But throwing up our hands and saying it's too complex isn't the solution, right? Because these AI tools aren't going away.
I didn't
Yep.
say I was.
Yep.
But
I'm
I
just
think we
saying
have
it's
to
not the
recognize
solution.
that
So we
it
got to
is,
figure out
yeah.
what the guardrails are, right? And in many respects, I do think that the General Data Protection Regulation and the approach taken by the Europeans does a beautiful job at encapsulating some of the concepts that you're raising, which are things like a balancing test. Article 22, as Matt mentioned, requires human intervention in automated decision-making, so you have the right to object and require human intervention. And what does that look like? That's a session I talked about yesterday. And then there's also the Articles 5 and 6, where you must have a legal basis for processing. You have to show it's job related and that there's a legitimate business reason for the data. But it also requires in Article 5 the principle of accountability. You need to document what are your policies and procedures, what are your ethical practices around data. And then the privacy impact assessments is another component that is codified in the GDPR, which we see in this new proposed federal legislation. I think we keep seeing patchworks in the United States of different legislation, and it's becoming, especially with some of the really nuanced requirements of CCPA, potentially conflicting new Nevada law. Now you've got the Video Protection Act. It's just, if we developed a more harmonized approach that models more closely to Europe, I think that kind of framework principled approach, companies would actually it would be easier for them to follow.
The problem, Heather, in that is if you look at the growth of employment law and regulation right now, it's the patchwork approach. You know, with what's broken in Washington, we're seeing not just in the privacy area, but in the employment area, states, localities, New York trying to lead, Illinois trying to lead, even though we have one of the worst economies in the country. But, you know, in terms of regulation, you know, when we were sort of starting 25 years ago in employment law, you used to have one law for basically 49 states and one for California, and now it's totally different. Right. Matt, I'd like to get your thoughts, though, on are the state laws, I mean, they're getting so specific. We're talking about the Illinois Video Interview Act, the proposed federal law that Pauline's suggesting. Is that the balance that you're talking about between sort of harnessing the insights of data while protecting employees in the workplace?
I agree. I agree with Heather that a more comprehensive approach would be useful. Again, I don't think it's I think there are a lot of still contested areas within the GDPR that we'll have to see how they play out. And it's one of the I think it's one of the positive aspects of the law is it is principles-based. And I think particularly from an American perspective, getting used to the idea that it's not just the data that you collect, how you collect it, but you have to use it in a certain way, right? We have this kind of, I think, approach in this country that if you collect it properly, you can kind of do whatever you want with it because it's information. But the GDPR says no, that has a connection with someone and they still have an interest in it, even though you have it, it's about them. And so they still should have some sort of role in saying how you use it. And, you know, that you may need to destroy it down the road at the appropriate point. Or in the Google Spain case, you may have to forget the data if you're a search engine, and that's a fascinating area. But so I think the you know, the social media accounts, you can't hand those over to the employers. There are certain things that kind of grab people's attention, right? And you're going to see state litigation or state legislation, excuse me, in that area.
By the way, when you get state legislation, you get state litigation. You know?
Right, yes,
You
right,
mentioned the
right.
Illinois biometric law. It is
Right.
now one of the largest sources of class action
Yes, right.
litigation in the country.
Right.
So,
Right.
you know, with state regulation, you know, much like GDPR created an incredible sort of regime of compliance,
Right.
this, you know, fairly unknown law with a couple of lawsuits is the most sort of litigated statute in the state of Illinois and the most litigated privacy statute now in the country.
Wow.
You know,
Well, I think that's, just to finish up, I think that's why you're seeing a push. I was at the International Association of Privacy Professionals Conference, and they're actually more optimistic about federal legislation in this area than I expected because of California, the CCPA, but also because of these other statutes that are rising. We're getting to the point where at least there's almost a sense from even some industry folks that, hey, we want to have a federal regulation that would preempt, you know, a lot of the state regulation, but at least then we would have more of a sense of, you know, the boundaries. And, you know, people are leaving Facebook because of privacy concerns, and the industry, I think, is beginning to recognize we may need regulation to protect us from the worst elements of us, of the industry, so.
Well, it's interesting. I was just, Sam's been talking about in the sort of crush of wage and hour class actions, whether or not there would ever be some type of preemptive element to a federal statute. I'm skeptical that we'll see that kind of sort of thoughtful approach, but Laura, you were something you wanted to add.
I just wanted to say, and I think that, you know, Heather's presentation was really impressive, but I think that presentation and the other remarks underscore the fact that there's no transparency at this point. People don't really understand that the information they're giving prospective employers are data. They don't understand how a video interview might be used. I mean, they don't understand that that it's not about the content, what they say, it's maybe how they move and what their accent is. So, you know, if there's an interest in really using this data to eliminate bias, then tell us what it's about. Because I don't think most people really understand what's going on. They don't understand, you know, within the employment context, and they don't necessarily understand, for example, how facial recognition software is used, you know, when you go to JetBlue and stand online and they're looking at your face instead of your boarding pass. So, you know, look, maybe if we know more, then I wouldn't have the same concerns that I have now, that I'm fighting, you know, an unseen enemy, and I don't have the tools. And for an individual, you know, plaintiff, how are you going to afford this? This is thousands and thousands of dollars of expert time. And, you know, I agree, employers don't want to spend money, but, you know, that actually hasn't been my experience. People have thrown money at things that they could have settled for a dime. So I don't get it. But, you know, maybe one day in the fullness of time I will.
Heather, what about, we've got only a few minutes left. We talked about sort of new statutes that are preventing the use. What about the growing sort of use where there are rights being created so people, and Matt mentioned this in his comments, where you have your own data and you have a right to it. Is that another sort of angle where we're going to be going? You know, because the data is now useful. The data is valuable. I mean, all these large companies, that's what they're selling is our data all the time. Where does that fit into this puzzle that, as Lori points out, not very many people understand?
So data subject rights are one of the foundational principles of the EU's General Data Protection Regulation, and those were part of the 1995 directive. They were expanded and codified in the regulations. So data subject rights have been around for a long time in Europe. We're just now starting to see them here in the United States. CCPA is a great example that provides the right of access, the right to knowledge, the right to deletion, right? But even under the CCPA, the exceptions under the data deletion requirement includes exception number 9. It basically says if you have a legitimate reason to keep the information, you can deny the deletion request as long as you maintain that information and only use it for internal purposes. So what are internal purposes? Maybe that's something the regulator, the Attorney General is going to define more for us what that is, but that strikes me as a
We've been
pretty big
struggling with that even as a law
loophole.
firm, what is internal purposes,
Yeah.
you know, as you're trying to communicate with clients or, yeah, no.
Backup tapes is an obvious reason, right? But this kind of internal modeling and use for making HR decisions, is an HR decision an internal purpose? I don't know, you sort of get into a little bit more of the gray area. So I would say that, oh, we have a question in the front?
Yeah, usually.
Always at the end.
Microphone, please, Larry.
Oh.
The microphone, identify
Oh,
yourself.
Right behind you.
it's simple. How is the word formula different than algorithm?
Oh, it's the same thing. Algorithm sounds fancier. Formulas, it's a mathematical formula, is an algorithm. Oh, here we have a
Uh-oh.
math scientist. I
Okay.
was gonna tell the difference. Bring the scientist up to the front.
Oh,
Bring
yeah,
the mathematician.
we'll have her answer, and then I think we have to move on, because we've got our lunch and our esteemed luncheon speaker.
Here
So
we go.
tell us the
Yeah.
difference, please.
Very sorry to jump in, and I'm also going to be on a panel at the end of this of this conference. But a formula can be a calculation according to a formula can be one of the steps in the processing of an algorithm. So an algorithm encodes a sequence of steps, like a recipe, right? How do I cook dinner? In what order do I first I open my fridge, then I wash the ingredients. And one of these steps could be a very, very complex calculation, but it doesn't have to be.
Okay. I think, Fred, I think we are out of
So
time,
he
but
used
we're
the
glad to
word
talk.
formula.
Yeah.
Yeah, I think we are. Okay, let's give this panel the round of applause that they deserve.